over to Professor Neuborne to actually talk about what is on the table.
Okay. You want to go first, Jim, or shall I?
You go ahead.
Okay. First, I'm delighted to have you to be part of the panel. It's wonderful to see folks who are not lawyers thinking about these issues, because ultimately these issues are much more important than the kinds of stuff that lawyers usually do. It's something of a challenge to discuss a pending Supreme Court case and not slip into legalese, and I'll try not to do it. I'll also say, forgive me if I'm not encouraged about the lawmaking process.
I'll tell you after. All right.
Sometimes I think that it's like, it's like Bismarck's description of what goes on in the government. It's like a sausage factory. You don't want to know. The result tastes okay, but God, you don't want to know what goes into it. So the case is pending before the Supreme Court, and it's fundamentally, I see it, as divided into two broad legal issues, which may or may not track with the kinds of policy issues that you guys are thinking of. But the way I see it, there are two broad and important issues. And by the way, there's a strong misunderstanding in the public that this is somehow a First Amendment case, that this is somehow a free exercise of religion case. Technically, it's not. Technically, it's a case that comes up under a statute called the Religious Freedom Restoration Act, which is a response by Congress to a decision by Justice Scalia back in 1990 to lower the level of protection for free exercise. The pre-1990 protection for free exercise cases was, did it really substantially impede behavior that was strongly religiously motivated? And then we would think about whether we would grant an exemption. Scalia said, no, no, no. You have to intend to target religion. So the 1990s case was a case involving Native Americans who smoked peyote in age-old religious ceremonies and who were being prosecuted under the drug laws for possession of hallucinogenic drugs. And when they said, no, no, we get a religious exemption from it because it's being done in connection with our religious ceremonies, Brennan, for the liberals, said, yes, great, you should get a religious exemption. Scalia, for the conservatives, said no. No religious exemption, because the guys that passed the drug laws weren't thinking about religion. They weren't trying to ensnare religion, and therefore you don't get a free exercise right. Now that set off a huge controversy among people who really care about religious freedom, including me and including the ACLU. Congress passed a statute designed to overrule that decision. And it's called the Religious Freedom Restoration Act, which says that when somebody invokes a right to a religious exemption from something, you don't use Scalia's test about asking whether it was intentional. You ask Brennan's test. Does it have the effect of interfering with your religion? That statute then went up to the Supreme Court, and the Supreme Court declared it unconstitutional as applied to the states, saying that Congress had no power to pass a statute overruling one of their precedents as applied to the states, but they left it in effect as applied to the federal government. So now you've got this strange situation where the statute, where if a state did this, we would be talking about it under the Constitution. But because the federal government does it, we're talking about it under the Religious Freedom Restoration Act. And the first issue that comes up is a statutory construction issue. It's not a grand, monstrous free speech issue, although I'll come back to them, a free exercise issue, although I'll come back to it in a moment. The first technical question that comes up in the case is, because the plaintiffs here are corporations, seeking an exemption on the grounds of religious, strong religious belief. The first question that comes up is whether a corporation is a person within the meaning of the statute. The statute says persons raising religious claims get this benefit. And so the question is a corporation a person? And, you know, it's the term person in the law law professors have gotten tenure on nothing else, worrying about what person means in different contexts. And there's an antecedent case, there's an old case from the 1990s, saying that a prisoners' union is not a person within the meaning of the definitional act that people usually cite, because the prisoners' union, if you look at it in context, was going to be engaged in things that only an individual could do. And therefore, the entity, the aggregate entity, was not a person. So the question is, we have to ask whether a corporation here is a person. But until you can know whether corporations can exercise religious rights, you can't answer that question. So to say that, oh yes, a corporation is a person in the statute begs the central question about whether corporations can pray. Now, I've written many times that corporations pray, P-R-E-Y, P-R-A-Y. And so, but the question is whether a corporation is capable of exercising the dignitary activities of religious observance that really underlies the protection in the first place. And the big precedent that gets cited is, hey, in Citizens United, they said corporations could give an unlimited, could spend an unlimited amount of money. So if corporations can spend money, of course they can exercise religious freedom. And of course, the narrow thing that people, I think, sometimes are overlooking, but the Supreme Court won't, is that Citizens United was not based on the right of the corporation. In Citizens United, they said, we don't decide whether the corporation has a free speech right. There are hearers out there who need the information. And so what we're doing is allowing the corporation to borrow the hearer's rights and use it as a defense to give the hearers what they need. So that Citizens United is essentially a third-party case. Now, if there's one, I don't hold myself out to be a specialist in religion, but if there's one thing I know about prayer and about religion and about religious observance, is that it is not a third-person doctrine. It's a doctrine that's central to you. It's your internal beliefs. It's your internal soul. It's your relationship with the unknown and with a potential creator or some spiritual force that's involved when you engage in religious activities. And so the third person that was necessary for the borrowing in Citizens United is not present in these cases. And the court is going to have to decide whether corporations are really things that can pray, even though they're artificial entities with no soul. It would be like asking whether robots can pray, or whether abstractions can pray. And that's going to be a very interesting thing to see. And my prediction is they're going to avoid it. They're going to say, well, yeah, maybe big corporations, maybe huge corporations, we have this problem with, General Electric may not be able to pray. But these are small corporations. These are family-owned corporations. Hobby Lobby is not such a small corporation. That's 1,300 employees. But it is a family-owned corporation, and you should look through the corporation to the family shareholders and say that those family shareholders are in effect the corporation, and if they pray, and if they have strong religious beliefs, you should respect those beliefs even though their business is organized in the corporate form. They have even a stronger argument when they get to the Conestoga Woods case, which is the case that is joined with it, which is really a small group of Mennonite woodcarvers that are organized in a corporate form, but this is a really small group of people. And so the question is, why can't we pierce the corporation, go through the corporate entity, and say it's the individuals whose religious rights are at stake, and surely they're persons, and surely they're entitled to protection. And the answer is that it's troubling to think that I would say, great, I have no problem with that. I have no problem, for example, if it was a nonprofit corporation. Nonprofit corporations, I have no trouble saying, just they're collections of individuals, so treat them as collections of individuals. But a for-profit corporation is a very different animal. A for-profit corporation benefits from four things. It benefits from limited liability, which means that the shareholders are immune from the debts of the corporation. It benefits from separate status so that they can have separate taxpayer. They can manipulate the tax laws, like Caterpillar, creating a Swiss subsidiary and all of a sudden avoiding taxes because it was two corporations. It has lifetime, it never dies. So the corporation goes on forever, and it has entity shielding so that if the shareholders get in trouble, the corporation's not liable for it. Now, those are hugely valuable legal privileges. It's why the corporate form is the dominant form of capitalist investment, because it has those great benefits, and every one of those benefits turns on recognizing the corporation as an entity which you can't pierce. You can't go through the corporation and get the shareholders' money. You can't go through the corporation and collect the shareholders' debts. You can't go through the corporation and do taxes unless the corporation decides to allow you to do that. But to suggest that this is a one-way street where the people inside the small corporation get to pierce the veil when it's good for them. When it's good for me, I want you to treat me like a group of individuals. And forget about that corporate thing. It's really not very important. But when it's also good for me, I want to say, boy, is that corporate thing important, and you can't collect debts, and you can't tax me. So the question is the Supreme Court going to sit still for a one-way street in corporate settings? And based on the oral argument, my prediction is yes. Based on the oral argument, I see 5 votes for saying that small corporations, small family-owned corporations, ignore the corporate barrier. Now, interestingly enough, if I were the Chamber of Commerce, I would not be very happy at that, because once the barrier goes down from inside, it's a matter of time until it goes down from outside. And they are now playing with the integrity of the corporate form as an investment mechanism in the country, if this works. So that's the first argument. The first argument is, can a corporation pray, and is this a corporation? Let's assume the answer is yes. And that raises the non-lawyer issue. That really raises the central issue. The central issue is, when do we give exemptions to people from the ordinary requirements of citizenship? Because fulfilling those requirements would really interfere with your religious conscience. And obviously, this is a very important question for a society like ours that has a free exercise clause and that takes religious freedom very, very seriously. So when do you exempt and when you don't? When do you don't? Let me give you what I think is the paradigm example. Paradigm example is conscientious objection from the draft. Let's assume, you guys, I hope you never experience it, but when I was your age, there was a draft. And you went in and they pulled you in to fight in Vietnam, or to fight in whatever war we were waging at a particular time. You didn't have a choice. You got a draft notice, you had to go. And many people said, wait a minute, I have a religious aversion to war. My God tells me that there's no such thing as a just war, and that you cannot have a war. Please let me out. Don't make me violate my conscience. Don't make me have to stand between God and Caesar. Don't tell me that either I listen to God or you put me in jail. That's an existential judgment that nobody should have to make. And we said the answer is no. No free exercise exemption from fighting. And why? Because if we give you an exemption, you shift the cost to somebody else. Somebody else has to go and fight if you get the exemption. Now, that doesn't mean that we as a society ignore the religious value. We then, if we have a democratic mandate for it, we then pass a statute to say, look, you're not entitled to a free exercise exemption, because that would cause costs to be passed on to somebody else, but we'll work out a mechanism, a statutory mechanism, and the phrase we use in the law is to accommodate. We will accommodate your religious values by providing for statutory conscientious objection as long as you agree to perform alternative service of essentially equivalent value and equivalent difficulty. So under those circumstances, we've made a compromise. We still shifted something to someone else, but at least the person getting the benefit is forced to give something back to the community. The brief I filed for the Brennan Center in this case is that if you look at our free exercise cases, beginning in the 19th century with the cases that say that there should be a free exercise exemption from laws banning bigamy, Mormons in the 19th century were cruelly prosecuted. They really went after the Mormon community for having bigamous marriages. And the Mormon community attempted to defend itself by saying, but these marriages are religiously, not only religiously authorized, they're religiously mandated under our understanding of the Mormon faith, which, by the way, is not the current understanding. But under the 19th century understanding of the Mormon faith, it was mandated. And so the Supreme Court, in the first major free exercise case, says no. No, we can't do that, because if we were to do this, we shift costs to the women and the children who we think would be raised under settings that are essentially invitations to abuse. Now, that may be right or wrong today. I don't know whether that's a correct empirical judgment. But the Supreme Court says no. No free exercise exemption from bigamy. From that day forward, in 25 or 28 consecutive cases, every single time the Supreme Court has been confronted with a free exercise case, they've asked themselves, would granting the free exercise exemption shift a burden to somebody else? And if it would, they don't grant the burden. Up until now, up until this case, they don't grant the burden. I'll give you the Paradigm case. The Paradigm case is a Connecticut case in which Connecticut, in good faith, passed a statute saying everybody should get their religious holiday off. If you're a Jew, you should get Saturday off. If you're a Christian, you should get Sunday off. Whatever religion you are, you should get your holy day off. And the employer has to give it to you. And the argument was, isn't this great? Because what this does is it advances the free exercise rights of the individuals by allowing them to pray without worrying about whether it interferes with work. And then someone came along and said, yeah, but what about the other people in the company? What about the guy who is not a Christian and not a Jew, but now has to work every damn weekend because he's got to make up for the vacancies that are created when you pull those employees out? And they said, we can't shift the burden to that person. And they said, not only would such a statute, such a burden-shifting statute, be a violation of not be a free exercise claim, it would violate the Establishment Clause because it would be the government imposing your religious beliefs on somebody else and making them bear the cost of your religious beliefs. Now, you apply that to Hobby Lobby, and in an ordinary setting, without the craziness of the right subjection to the law, without the intense subjection to what the right sometimes calls post-conception contraception, which they say is the equivalent of abortion. Without that kind of crazy intensity, this would be an easy case. This would be an easy case. We'd say, wait a minute. The benefits that snuck into the law through this brilliant process that I'm going to forget as soon as I can, the benefits that snuck into this law that are now available to women are somehow going to be snuffed out because the employer doesn't want to give it to them, because the employer says he's got a religious exemption. Suppose I have a religious exemption to minimum wage, or a religious exemption to maximum hours, or a religious exemption to health, or a religious exemption to unions, or a religious exemption better. I'm developing one very quickly as I get older, a religious exemption to taxes. Can I somehow say, because of my religious exemption, you got to shift the cost of my burden, of my benefits to somebody else? Now, it's no answer to say, no, we don't want to hurt the employees. Let the government make up the difference. Let the government pay for this. Because if the government pays for it, there's no such thing as the government. The government is you. If the government pays for it, your taxes pay for it. And it means that your taxes are going to pay for somebody else's religious beliefs. And that's what the Establishment Clause is designed to prevent. That's why you can't have taxes to support religious schools, because we don't allow taxes to be used to support somebody else's religion. So the argument somehow that this is an easy, free exercise case because these people really care, I believe they really care. I do believe they really care. I believe they're sincere, especially the Mennonite, Conestoga Woods plaintiffs. They really do care. And the answer is, you can't, we'll do anything for you, but you can't make your employees pay for this. Maybe the employees would waive it. Who knows? Maybe there are ways that one could work this out that wouldn't force you to do it. But you can't say, I have a constitutional right to be exempted from this law and make my employees pay for it. Especially my women employees pay for it just because I feel deeply. Now, here's where we're going to lose. Up until now, I would bet anything we were going to win. Here's where we're going to lose. We're going to lose because there are 3 sets of exemptions in the law. And the argument is going to be, hey, wait a minute. If you have lots of exemptions in the law, it means that the law is not very important. And if the law is not very important, so what if we take this stuff away from the women? You've already internally signaled it's not very important by creating the 3 exemptions. And the 3 exemptions are, first, the exemption that says that nuns and priests and core religious institutions don't have to violate their beliefs. Now, the notion that if you give an exemption to the nuns and the priests, everybody else has to get it, strikes me as being absurd. And the net result, of course, would be no exemptions for the nuns and the priests. So that doesn't help free exercise, and it doesn't help otherwise. And if that were the only exemption, I'd say no problem. No problem at all. The second exemption is an exemption for size. The law applies, what, 50 employees? You have to have a certain number of employees to have the law kick in. So it's a big little exemption. Now, the big little exemption in regulation, in economic regulation, is usually keyed to the fact that Congress can only regulate things that affect interstate commerce. So they make a presumption that if you've got 50 employees, you're big enough that you're going to affect interstate commerce. If you fall under it, you're probably not, or at least there's a danger. And also, big companies can absorb the costs of regulation better than small companies can. So they make a simultaneous decision about power and about efficacy of regulation and say the small should get out. But that exempts a lot of people in this country. Most people work for entities that have less than 50 employees. So all of a sudden, the women that work in the small places don't get the same thing that the women that work in the big places do. And the argument is, hey, if you care so much about it, why don't you let the small places out? And then the third one is the hard one. The third one is the toughest one. That one, I think, again, could be defended on the ground. Well, we let the small ones out because we didn't know we had power to regulate. Or we let the small ones out because we didn't want to drive them out of business. I think that would have been enough of a discussion. There's a third exemption. The third exemption is a grandfather clause exemption. The grandfather clause exemption says that if you have an existing plan in place and it doesn't cover this, you don't have to cover it until you change your existing plan. In other words, as long as you keep the plan in place that was in effect before, you don't have to change it going forward. Hobby Lobby, for example, would have fallen under the existing plan exemption, except they changed the plan. So they then fell within the law. So that it's much harder to defend the grandfather clause exemption. I think there's a good argument for it. The argument is if you're phasing in something as huge as affordable health care, changing so many things in so many ways, creating so many administrative problems, it's good to phase it in slowly instead of dropping it in on everybody. And so this is essentially a phase-in statute. But now we're getting to the point where the combination of the priest and nuns exemption, the combination of the big little exemption, and the combination of the phase-in exemption leaves more than half of the workers uncovered. So if you're gonna say to the Supreme Court, oh, don't let this guy out, don't let his religious beliefs shift a burden to anybody else, it's terrible, the Supreme Court is asking you, what's the big deal? You've already created 3 huge exemptions, why not create this little one? This little one for the believers. It'll be smaller than the 3 that you've already created, and what's the big deal? Especially when we've got a statute that says that you have to show that this is that there's a compelling interest and no less drastic means of advancing the compelling interest. 5-4 on those grounds. That's my prediction. We're going to lose it on the internal Swiss cheese. I think it's unfair. I think we should win it because yes, there are 3 big exemptions, but each exemption standing on its own is clearly justified. You justify saying priests and nuns toleration is why we do that. Big little we do for obvious reasons, and transition we do because it's the only way to transition in a huge program. The problem is it leaves the government vulnerable to the Swiss cheese argument, to the argument that there are so many holes in the cheese that it's not worth upholding. And that's the vulnerability. That's the vulnerability. And so we'll see what happens. Jane, what do you think?
Jordan. Jay is with that. Yeah, that's all right. That's
I keep losing to Jay. So.
Yeah. You know, it's interesting, and I want to thank you all for inviting me here. Our position, just so you know about where we stand, is that we represent 8 companies right now against the Obama administration. We have injunctions in all 8 cases, some from courts of appeals, some from district courts. Some are pending this case, some aren't. Some are a little bit different because the facts are slightly, let's say, you could say that they even have better arguments. They've never provided this. They're Catholic. They're tiny companies. We also represent one that's it's owned by 2 brothers, but is basically a grocery store chain, fresh foods, and they've never provided this coverage. So it's not like Hobby Lobby, where after they found out they changed it, so their employees have never received it. They never paid for it. They're very careful on their investment programs and plans. And so that's where we are. Obviously, we filed on the position of Hobby Lobby. We support that. And just as I go through kind of the analysis, and I hope the professor's right, that it's 5-4. Maybe there is a way I think that it could be a little possibly broader, is looking at whether or not this was just not the least restrictive way, is how you would look under the law for the government to accomplish what they could still say was compelling. So could you get another justice like Justice Breyer, who brought that up in court at the oral argument, and say, listen, it's a compelling interest, but there are other ways of going about this, tax credits, so that they can transfer money to the employees, and then if the employees want to do this, they can. But right now, it was interesting, some of the justices brought up the idea, well, why don't you not pay for insurance? That seems like the opposite of what we wanted with the Affordable Care Act. Now we have justices saying, because of this provision, just don't pay for the insurance. You won't be subject to the same fine. You know, the fine for this is more every day than the fine is for not giving any insurance at all. This fine is $100 a day per employee. So if you're Hobby Lobby, it's almost $40 million a year. But if you don't want to give your employees anything, and you're not mandated to pay them more if you don't want to, it's $2 grand a year. This again goes back to the idea of why this is more difficult than I think a lot of people looking at this on the outside, without getting into the details, say, why is this so difficult in court? This seems like one of those issues where if they want to mandate this, can't the government do that? We pay for things under Title X. A lot of us don't like funding to groups like Planned Parenthood. Doesn't matter if you object or not. If you pay taxes, the money is going there. Now, Planned Parenthood can't use it for an abortion, but they can use it for everything else. So, and education. So the idea here, again, that there are times when, and there's Supreme Court precedent, when if you can't say you don't want to pay your taxes. You know, the court has been clear. And even when the court has said, well, there are some exemptions for not paying your taxes, in one case, in the Lee case, the exemption was only for individuals. So it wasn't defined as persons or organizations. And so they said, you're a corporation, you're not an individual, your exemption's not meant for you, you got to pay your Social Security taxes. And that was that. So the parade of horribles, as it's called, the idea that if we allow this exemption, we will be flooded with all these other exemptions. You know, Chief Justice Roberts, in the oral argument, said this is not about Exxon. Exxon trying to assert this right would be ridiculous. It's about the Green family and Hobby Lobby. It's about the Conestoga family. It's about some of the families we represent. family businesses? Or are you in a lose-lose situation when it comes to incorporating? Lose on one side, so it's kind of like if you incorporate it all, because then you no longer can bring a RFRA claim, or a claim which is basically an instruction of how the courts need to interpret First Amendment claims. Or two, do you lose because you can't bring it as the individual owners, which is what the government's position is. Is it either way, so you can't win. There's no way for you to move forward. So when you look at that, and how the government went about the case, I think the weakest part of this law, and the reason why that it may shock some people if the court strikes this as unconstitutional, we hope it does. It's always tough to predict. People are wrong, and most of us are surprised with cases like this. But I think what the dean said is probably why it's such a weak argument. Tripping into essential care is not essential. Well, and so it's tough to cover something when you trip into it that's not in the legislation, that Congress didn't authorize this. It's not mandated like the coverage for 26-year-olds. Effectively, this can be changed by the political process as well. If a Republican, pro-life president comes into office, they can then change the definition of this. It doesn't require congressional legislation to do so. It was just they instruct the Department of Health and Human Services. So some of it is you can be upset that the law wasn't written the right way, which would have been to identify this care. The problem is it probably would have not gotten the 218 votes in the House and would have had a tough time passing. So instead, HHS was given a pretty broad opportunity to define what was this essential care. Originally they did not want to make the same kind of exceptions and exemptions. I think knowing that that causes trouble legally down the road. But eventually the pressure was there, and there's actually one more exception, or if you want to call it accommodation. If you're not a religious employer, and that means like a church, even the group of nuns is not a religious employer under the law. I mean, they started, and this gets them in even more trouble, I think. They start to find the difference between a religious employer, a religious organization, and then it's if you're under 50 or, in the grandfather clauses. A religious employer is the churches. They are completely exempt. They don't have to file paperwork. They don't have to let the insurance company know that it's still free. But if you're a religious organization, like Little Sisters of the Poor, who right now gets as a stay as an injunction against the mandate, which doesn't necessarily turn on this case. Remember, the court could look at them differently because of they are religious in nature, and the government acknowledges that. But they have to, and this is a group of Catholic nuns, sign a form that instructs the insurance company to instruct their employees that you get all these free contraceptives. So effectively, if they weren't paying for their employees' insurance, their employees wouldn't get this for free. But if they do, their employees get it for free, and they've got to sign it. So they've actually got to instruct the insurance company, tell the insurance company. And that's a different level of accommodation. And the court actually asked here, and asked the attorney for Hobby Lobby, if Hobby Lobby was given accommodation like that, would it go far enough? And would it be different even than a group? Now, he didn't say, because it wasn't part of the case yet, if Hobby Lobby would accept that. But it's always the government looking and say, okay, if we do create this exemption, or if this is a substantial burden on the religious beliefs, then we've got to carve out some way for not just for it to be the least restrictive way of going at it, but also so I think that what we saw here is can the government argue it's compelling? Maybe, but it still loses on the next point. Even before you get to the fact it's that there are other ways you could have gone about it. I don't think dropping insurance coverage is the best way. That also raises another RFRA claim. If you instruct a company who has deeply held religious beliefs, which the court basically accepts in oral argument, they accept that those are genuine and they move on, then are you going to instruct them to drop coverage? Now, if you drop coverage, you could be violating another part of your religious faith, which is, of course, you feel like you should be giving people insurance. So, I look at it that way. I want to go to the third-party burden issue. If they do this, doesn't it hurt the employees? If we look at other areas of First Amendment law, the court has no trouble with that. And when it comes to the First Amendment, the freedom of speech, Snyder versus Phelps, the protesters at military funerals, most of us abhor and don't like. But the court said, sorry, we're going to protect the freedom of speech. over the burden that it has emotionally, financially to these military funerals. So there, the court says, okay, we're going to go with the constitutional right in the First Amendment. On the issues like the press, in the New York Times case, you know, there's an issue of national security raised. There's an issue then of, well, it affects third parties, of course, if this is a national security issue, and the court said still, freedom of the press. And if you look at, I mean, there's more, but even Miranda, the basic Miranda rights, by not going through those, if you violate them, you can let a criminal go, which could endanger the third party. You know, it could endanger, violent criminals can go. And it could endanger others. So the burden issue, if it always burdens, you know, if it's going to burden someone else, is there a constitutional right anymore? Well, then you'd have no rights under RFRA. You would never be able to bring a claim because every action is reaction. And so that argument, again, gets back to the idea of you lose this way, you lose the other way, you can't win. And there's a difference between saying, and this at a level, you know, we're not going to open businesses on Sunday. And there were cases where the court said that's okay, even if you're a Jewish business. We can't force you to do that. And we're not going to change that. So the court is not always stepping in and saying everything is, it's actually the opposite. I mean, if you listen to the professor, it's very rare. So where's the parade of horribles? It's very rare to get these kind of exemptions or exceptions. And in this case, if we were talking about this was in the law, not something done by administration, by agencies like HHS, which can be changed the next election cycle and next presidential election cycle, and it was part of the law itself, or there were not exemptions like the issue for those who are 26 or younger staying on their parents' insurance, then we'd be in a different case. But the government opened itself up once you started granting some, and it was interesting in court, the idea, okay, because all of this goes back to what Professor originally started talking about, which was, can these corporations even assert this right? Now, you know, like as I said, you know, the court was not so concerned about every company doing this, obviously, not big corporations. They don't think that would have weight. So again, you know, that would not be heard, not have to go through the whole legal system. But when it comes to a family or a few people, that it's a different case and that the court has to look at it. And so, you know, I would say on that front, on the issue of do corporations have this right to free exercise or protection by RFRA, the real question is not all corporations. The real question is, do for-profit, closely held entities, do families who incorporate get those protections? And if so, what's the extent? And if not, why? I think Citizens United is actually broader. It opened up an ability, you know, for the speech at the largest level. It doesn't impact just not 3 people. We're talking about closely held corporations. Again, a different case, not what we're discussing today, and unlikely that we'd ever be discussing in the future. At least when it comes to this, could Exxon assert this right? Could a major U.S. company say, you know, we have a strongly religiously held, when we have all these different shareholders and a different board, it's a very different setup. So we have to remember what we're talking about here. And then ultimately, when the professor also says it's not about free exercise, what Congress did and what these federal laws do have to abide by, and by the way, since the law has been in effect, it has not significantly opened up a totally different world that we live in. It's been in effect since the 1990s. It was signed by President Clinton. And it was to correct some of the Smith wrongs, if you will, in the case that was referred to. But it didn't stop. It hasn't substantially changed, I don't think. I mean, it's rare. This is why we're talking about this case. It's a rare case. So the parade of horribles argument, which some of the justices brought up, justices who I don't believe will go against the mandate and had no intention of going against the mandate, are nowhere to be found for the most part. I mean, there are cases that move forward, but very few that get to the Supreme Court. And on top of that, very few that get there through RFRA. And to add even further, if the court wants to have it, which it usually does in these situations, narrow opinion, it's, listen, the government, weak case here, you give exemptions, you don't even just give exemptions, then you've also come up with a new category of accommodations. So now you're starting to parse religious groups. And then you also, if they're a smaller employee, or if it's a grandfather clause. Now, also the grandfather argument is a little bizarre because most insurance plans at this level change constantly. So I mean, that was only going to last so long. The government actually probably got that one right. I mean, that was a quick change. But the difference here is, I mean, we have to remember that ultimately we're talking about agency rules about what is essential preventative care that can be changed, with or without this case, 2 years from now. Now, there could be a case over that. Can you go back and change? But that's how easy this is. This is not a congressional act. And in fact, Congress did not specifically say to do this or not do this. Now, when it comes to the issue of abortion, obviously the overriding came up in court. And it was a bizarre exchange. It was Justice Kennedy who kind of brought it up through this line of questioning to the Solicitor General. And the Solicitor General, and this goes back to what I was talking about, that how, you know, if you can't win, if you incorporate, as you and your brother and your dad incorporate a business, and now you can't bring it individually. This is what the government's position is. You have no individual RFRA claim. But you also have no corporate RFRA claim. So you have no way of getting to court on this. Not even getting your voice heard and your case heard and your day in court. That ultimately, when we look at that and add to it, I think the exemptions that we're given, again, the accommodations, we have not just a situation in the abortion issue outstanding. To answer that quickly, what happened was the Solicitor General was asked, would this also include abortion? Could it include actually mandating that employers pay for abortion procedures? Now, it's interesting, the Chief Justice chimed in and said, isn't that what we're talking about here? Now, to some extent, that's true. Some of these groups believe that these abortifacients are included. That's why Hobby Lobby is only excluding 4 of the 20. And these cases are a little bit bizarre on that, too. I mean, it's not like they all want full exemption from this. Some are saying, we're fine, you know, giving 16. And that can be part of the plan. It's just these 4 that we have a problem with. Some are saying all, you know, and it goes between, you could kind of think Catholic groups to other religious groups. So you look at that, and I'll kind of close it. So the idea that the government said yes, but there's no law like that now. Now, there's a federal law prohibiting taxpayer dollars paying for abortions. There is no federal law prohibiting a mandate for private corporations to have to do that. Now, the law would have to pass, or HHS would have to interpret it that way if you wanted to go there. But again, the idea that anything is so essential, I think, is what would really hurt the other side of this case and the position, is that if it's so essential, if it's so necessary, why did you leave it up to the political process years down the road? And why, when you did that, did you start giving exemptions to people? If it's not abortion, and if it's not about abortion, which a lot of the proponents of the HHS mandate have said, then why not mandate that the churches pay for it too? Shouldn't they have access to it in case they need it? We're talking about something that is effectively free, and for the accommodation aspect of this law, then if we don't think it's okay enough to fully, if they didn't fully exempt anyone, could they have just said, well, and for those who don't want to do it, you still have to give it? Now, a lot of us have trouble with that accommodation. It wasn't an issue here. But effectively, if you insure your employees, you have to pay for their birth control or their contraceptives or what drugs you may believe are abortifacients, even if you are claiming the exemption as a religious organization, by signing a form that the insurance companies then instruct the employees it's actually free. Well, the employees would not have access to insurance through the corporation. So they would not be instructed by the corporations. People try to say, as the dean said, that it's not that we're not paying for it. But remember, how would these employees have access to it in the first place if they didn't get insurance from the company? So already there are a lot of troubles with the mandate. It's not just this provision. This is probably very telling. Listen, the court goes 5-4 on the mandate. I think you could see things like the accommodation even go so far as to say that is not going far enough in protecting under RFRA and under the First Amendment jurisprudence. And so I will leave it there. I think it can be very passionate. It can be an intense debate, but this is kind of one you have to step back a little bit if you look at the legal side of it. And if you are on the health side of things, you're undergrad here, you're on the health side, the public policy side of public health, this would be, I think, an example of if you thought it was so essential and so important, don't leave it up to things like HHS, put in the law. Put in the law, get the law passed by elected officials, and then it's a different interpretation and a different case entirely. It doesn't mean it couldn't be challenged, but it's certainly a lot stronger case that it's a compelling government interest to mandate this, and that the exemptions are going far enough and they don't have to go any further. Thank you.
So, thank you very much.
Thanks.
I just want to, let me just interject two things, and I'll turn it back over to Professor Neuborne. The first one is, in some sense, it is in the law. As I told you that story before about how it came up in USPSTF, the law has two pieces to it, right? The part that has to do with preventive services that all firms have to provide free of cost sharing, and the part that's called essential health benefits. So there is actually a part of the law that lays out essential health benefits, and reproductive health benefits are part of essential health benefits, and there's a separate procedure for determining what goes in essential health benefits that is actually a state. The states have to choose the essential health benefits based on some regulatory guidance that the feds gave. If this hadn't been in, the whole thing is that it's in the preventive services piece instead of in the essential health benefits piece, that it shows up, that it actually came out in this way. Essential health benefits are not grandfathered, there are no exemptions from them, they apply to all qualified health plans, they apply to all firms of all sizes, all small firms actually. In large firms, there's more complications, but fundamentally that's actually in the law. So if they had actually not had this sort of trip up with the mammograms, from a legal perspective, I think this thing would have been much cleaner. It would have just been one of the benefits that's mandated along with maternity care and mental health and substance use care and all the other things that are already mandated within the law under essential health benefits. The other piece of it, actually, which is, so we worked on the accommodation piece too, and one of the things that we looked at in that is this question of whether anybody's actually paying for the benefit. And this is one of these really perverse things that makes it so complicated. Because unintended pregnancies are so expensive, the insurance companies are happy to give you free contraception. So if they have to cover the pregnancy, they would actually rather cover the contraception. And there's actually a pretty big body of literature that suggests that this is the case. So that's what made the whole accommodation thing even plausible in the first place, because the insurance companies were totally happy to go ahead and give people contraceptive coverage without receiving any premium for it, because they'd rather do that than pay for the market, which is perverse, but there you have it.
This discussion reminds me of why I agree with a statement that first kill all the lawyers. Because what we've done is we've taken a very important public health problem that has an essential importance for the lives of millions and millions and millions of Americans, and reduced it to, by a series of slicing and dicing that I teach my students how to do every day in school. We've sliced it and diced it into small component parts that can be turned over and looked at as if they're irrational. And we'll never put the parts together again. I mean, only a lawyer can take a problem apart to its component parts and deal with the component part and then never worry about putting it back so that you see the holistic view. And Jordan has done that very well. I mean, you know, there's a whole series of slicing and dicing things. Well, this is technical. You could have done it better here. You could have done it better a little there. You could have done it better a little there. In any complicated statute, and I don't care what it is, any complicated statute attempting to navigate the political process in a complex democracy will have untidy provisions in it. And if one of the constitutional requirements is that laws have to be tidy and the best that you can do always, good lawyers will always find a lever and take the whole thing down. And that's what this is about. I mean, this is an attempt to get a handhold on an issue through a series of small, very, very technical issues. So let me answer a couple of them. The first one, that RFRA is not a parade of horribles. That if we decide this case under this statute, it's not going to change the world. It's been in effect since 1990. There hasn't been an avalanche of cases. Well, of course, there have been an avalanche of cases in certain areas in a companion statute dealing with prisons. But the fact of the matter is, the reason there hasn't been an avalanche of cases is because the Supreme Court declared the statute unconstitutional and inapplicable to states. So it has no application to any state regulation. So it's only federal regulation, and federal regulation does not, you don't have the same kinds of issues that you have in day-to-day regulation of zoning, all of the various ways that the state bumps up against people's religious values. It's much rarer at the federal level. So of course there aren't going to be very many RFRA cases. Secondly, the notion that if we grant this, there's no parade of horribles. Because there'll be so few, because we've said you can't apply it to taxes, you can't apply it to minimum wages, you can't apply. Well, that was all done when the law was, if it shifts a burden to somebody, you can't do it. You take that law and change it now and say, oh, you can shift the burden, and now you can do it. Every one of those cases is now subject to re-argument. Because if you can shift this burden, what burden can't you shift? And where's the principal stopping point about saying that there's a complete exemption? Then the third little technical piece is, oh well, this was put in the statute through executive action and not through the legislation. There's no constitutional principle, nothing, never, a constitutional principle that says that a statute is entitled to more constitutional respect than a valid presidential order. The United States military was desegregated in 1947 through presidential order. You're going to stay, is he going to stay, or somebody going to argue, well, if it was really important, they would have done it through legislation. And since it's not really important, it's not, we don't have to really pay attention to it. If there is an authorization in a statute that authorizes executive action, the executive action that comes out of that authority is the same level of law as a statute gets passed by Congress. To sort of argue that this is not important because it snuck in through the back door is simply to say that executive actions are not as important as legislative actions. And boy, that would be a revolutionary principle in American constitutional law. Just a couple of words about Little Sisters, because it reminded me of a case that I dealt with, and Jordan will find me very sympathetic to the Little Sisters issue. The Little Sisters issue is the group of nuns that run old age homes, and they give wonderful care to elderly people, and they give it at very low cost because they internalize the cost themselves, because they're loving people who don't require a great deal of payment. I mean, it's as a culture, we owe them a huge debt, and they employ people. And the accommodation that was worked out that said, look, church shouldn't have to do this, and neither should these nuns. These nuns should not have to be in a position where they feel that they're violating their conscience by giving this to their employees. We're going to let them out. All they got to do is sign the piece of paper saying, we're entitled to the exemption, we would like the exemption, and to the insurance company, go ahead and do what you're supposed to do without our getting involved. But we sign a piece of paper that says it. Well, the nuns, and I take this, I believe them, the nuns say we can't sign that piece of paper. That makes us complicit in the chain of activities to an event that we find is a terrible burden on our religious conscience. You can't make us be a chain. You can't make us sign something that will have the result of something that we find awful. And it reminded me that during the Vietnam War, when I was a young lawyer, I represented what we called they were complete resistors. These were kids whose religious beliefs forbade them from engaging in any kind of war, but also forbade them from cooperating with what they called the engine of death. So they wouldn't register for the draft, and they wouldn't apply for conscientious objection status. So that when they got indicted and they got into court, I used to beg the judges. I used to say, let them go. Let them go. They are entitled to the exemptions, but their religious conscience will not permit them to provide it. They went to jail in droves. In droves. Nobody cared about them. The consciences of the Little Sisters are more tender than the consciousness of these kids who couldn't sign the paper They couldn't sign the paper, and therefore they went to jail. I thought that was wrong, just as I think it would be wrong to punish the Little Sisters for being unable to sign the paper. I had one wonderful district judge, a man named Jack Mishler, who was the chief judge of the federal court in Brooklyn. And he once asked me to sit in on a case with one of these, they were called non-cooperators, with one of the non-cooperators. He said, I hate to send this kid to jail, I hate it. Sit there, and he won't let you be his lawyer, because you're a part of the engine of death too. So he won't let you be his lawyer, but sit there and listen. And if you hear something, tell me. You know these cases. If there's a technical mistake in the government's case or something, let me know so I can dismiss the prosecution. Government puts in a flawless case. And I signaled to him, I said, nothing, there's nothing there. And he said, okay, approach the bench. So the kid comes up, and I come up. And Mishler says to the kid, look, tell me why you can't fill out this form. Tell me why you can't apply for the conscientious objector status that you're so obviously entitled to. Tell me why you can't apply. The kid looks at him and says, because I will have no truck with the engine of death. You're part of the engine of death. I will have no truck with the engine of death. Mishler looks at him and says, I understand now. I deem that to be an application for conscientious objector status. I grant the application. Prosecution dismissed. Go home, young man. And then he turns to me and he says, you know, Mr. Neuborne, everybody needs a Shabbos goy once in a while. And for those of you who are culturally diminished and don't know what Shabbos goy is, Orthodox Jews can't turn the heat on the Sabbath. And in medieval Europe, that was a big deal. They couldn't stoke the fire. They couldn't get warm. What started as a marvelous tradition of religious toleration were that people in the community would come into the homes of the religious Jews in Holland and Germany in the 15th and 16th century and start their fires for them. And they were called the Shabbos goys, the non-Jews who on Shabbos came in and helped. It eventually evolved into a paid position, where you would pay people to come, and then it became you would pay people to come and turn your thermostat on. When I was a boy in Queens in the 1940s, I remember that my neighborhood had a Shabbos goy who came and turned on the thermostats for us all, so we could stay warm on the Sabbath, and then when the Sabbath was over, we could turn the thermostats off. And I remember what we used to do in return was we used to tutor the kids. He had 3 sons, and we used to spend as much time with those kids as was necessary to make sure that they excelled in school, because we were trying to pay back his wonderful act of kindness in coming. That was a time in this country when religious toleration really meant cooperation, instead of competing to see whose religious symbol you can stick in your face faster than somebody else's, which is what we've degenerated into. But I believe that there should be a national Shabbos goy. There should be a job of the United States Shabbos goy, and the United States Shabbos goy should fill out the Little Sisters paper for them, so they get the exemption they deserve, and we can then go forward. Which is what the court's going to hold. The court is going to rule in favor of them, and they're going to say, somebody's got to be allowed to do it for them. And they're right.
Before the ACLU, I guess it was better, a better religious situation than when we started going after the religious signals in court, and then everybody started fighting over them, which is now our situation.
No, I didn't start going after religious symbols until they were stuck in the faces of people who were sick of looking at them.
I think a lot of that came out of the fact that people started pointing out this thing and then saying, but not an issue tonight. I would just close before we take a question. Ultimately, the first step here is, do these corporations, can they assert even rights under RFRA? And just to point to one thing, most laws have all laws have definitions. So under RFRA, there's definitions, but there's not one for person. And that it says persons, but then you go back to the general definitions in congressional statute. And this is important for non-lawyers in here too. And in the congressional statute, the general definition of persons includes corporations.
No, unless the context requires otherwise.
Yeah, so again,
it's
open to court. But it does not, a person does not just mean only individuals. That's different. And so it leads it again to open question. We go to court over that issue. That's the first step. Is it intended to apply for protection to here? And then, there was, I think, in Conestoga, there was an individual claim also made, which is different than Hobby Lobby, but the court joined the two and focused mostly on, of course, the corporate claim. But you never know. Oral argument and what comes up and is important there, and what you may have seen in the news, is sometimes the least important of what ultimately these decisions entail. That's why you're surprised, kind of like this is now a tax in the Affordable Care Act, which is surprising to both sides. And it's because it didn't come up much in court. It wasn't a major briefing topic. So again, you never know what small angle of justice may pick to move forward here.
So I'm happy that Dr. Murthy has actually been able to come out of the OR, and we are almost finished with the panel, Dr. Murthy, but if we wanted to just speak for 5 or 7 minutes and just give some sense of your position, then that would be nice, and then we'll take questions.
I feel a little intimidated because now I'm like, oh. As a contraceptive provider and an obstetrician gynecologist, I really feel strongly about every woman being able, and every man in a partnership, being able to choose the time and place and method of having a family and growing that family. And, in that sense, contraception is a basic right. We have 3 million unintended pregnancies in the United States, half of those end in abortion, and we don't want that to happen. We'd like to ensure that every pregnancy is a wanted pregnancy and one that's welcomed into any family and whatever family unit as you may define it. So it's really hard for me to hear someone say, well, because of my religious beliefs, you can't have what you want. And I find that very difficult, and I find that, we have a lot of disparities as it is in women being able to get contraception. They have to pay more. 2/3 of private insurance require a contraceptive rider, meaning that women have to pay more to get the birth control that they need. So as it is, women have a difficult time getting what they want, and now to place a further burden on them and say, well, the job that I have, for example, working for Little Sisters or working for Hobby Lobby, if they're doing something they love but want to choose the time and place to have a family and to have a pregnancy, I just feel that burden being imposed by someone else on their choice is a difficult thing to stomach for me as a provider. And I come across it in the other end where, now they're coming to me and they can't afford what they want or are choosing a substandard method for them because of the limitations placed on them by the constraints of others. And so I'm all for the First Amendment right of practicing your religion, but it says very clearly to practice your religion without undue burden on other people. And so the Little Sisters need a Shabbos goy. I agree. If that's how far it's going to take, Hobby Lobby needs a Shabbos goy. Hobby Lobby and Conestoga need someone else to sign that exemption for them, although they don't have the same exemption, but they need to decide where their rights end and where and mine or anyone else will begin. I think I'll leave it at that.
Why don't we take questions then?
Yeah, absolutely.
So ultimately, I think Hobby Lobby and Conestoga are going to get their Shabbos goy, but mostly for you, Mr. Sekulow. Assuming that your position on RFRA is correct, I still have trouble separating this mandate from every other federal regulation on businesses. They're full of exemptions, exemptions for size, exemptions of agricultural employers from the NLRA, or exemptions for certain industries. I mean, the federal rules and statutes are not consistent. They all have holes in them, and they're all full of thousands of pages of regulation. Short statutes, thousands of pages of regulation. Clean Air Act, Clean Water Act. So if we allow closely held corporations, which aren't necessarily small, Koch Industries, Cargill, these are closely held corporations, to be exempt from this mandate, why shouldn't they be exempt from everything else? religious.
Or why couldn't they make a case?
Or why couldn't they make a case?
Yeah, I mean, you would
Why
obviously
should
not
just go to
exempt.
court every time?
I think here you look at what came together. So you would look at every one of those loopholes and say, okay, was there an exemption made because of religion to any of those laws? Here, there was. The government actually made the religious exemption. So if these laws about like labor unions or labor review boards, if they're not exemptions based on religion, and you can't bring it up, where's your RFRA claim? Because the government here, I mean, that would be much broad. That would be a step past this case, at least. Because here, the government said, these are religious exemptions. These are the religious accommodations. And you have to be not-for-profit in a church to get exempted. You have to be a non-for-profit religious organization to get accommodation. And here's the other, and then if you're not religious for our definition, you don't get covered. And then now you can bring the challenge. In this case, let's say they allow the standing and maybe go a different way on the mandate. And that's where I think the difference is. It starts at the government defining religious exemptions, and the government defining religious employers, and the government coming up with those categories, which I think opens that door, which is different than from every other statute and every other regulation. So that's the parade of horribles answer, is if the government wants to open the door and start parsing things based off religious belief or religious exemptions, and that's pretty broad, because they don't then go look and say, well, are you really believe this, or is this really important to you? So when they make that, it's significant. Then you get to bring the challenge.
Don't the employment exemption, the Employment Discrimination Acts have exactly the same set of exemptions? They exempt religious institutions.
The court has the court mandated that. Actually,
There's
they brought it out to the Hosanna Tabor case, like the schools, where they said schools still the professor cannot. It was 9-0 at the Supreme Court, because these are still specially treated. And the government was saying, not the Obama administration, but the government saying that they were specifically, it wasn't the Obama administration, but it was the school asserted again, we're religious, and then the Supreme Court saying, yes, you are, so you get this covered. And that's why. I mean, there was a religious, they write religious exemptions or exceptions in, and then, or it's judicially made, if you want to use that term, that the judges make these kind of exemptions, exceptions available. But those aren't available for every part of the law. I mean, that would be the answer.
That seems to me then, that begs the question then, why even put a religious exemption in the law?
Well, that would not be, I did not write.
No, I know. Is it a better suit to say, well, you didn't put a religious exemption in the law and you should, versus there is one and I don't fit the criteria, so now I want to fight it because I want to fit the criteria?
It's probably a better case if you're fighting it. If they've already exemptions made to others, it's a better case that you can get one too. I mean, that's always...
Right, it's always better because you have precedent, right? But
Probably the government created the precedent. Remember, it's not, you didn't go to court to fight that. The government started giving out. And I think some of this goes back to, as the doctor said, it's coming from a different angle, is, and again, I don't look at executive orders the same, because executive orders do change based on who the president is. So that doesn't solidify things the same way, unless the next president agrees. They can change those. But it's different than trying to overturn an act of Congress signed into law by the president.
Next Congress can change it too.
Yes, but the president has to sign it. He could veto it. There's different kinds. I mean, to compare executive order to laws is, I mean, I don't know. Going there, it's fine on the scale of what you have to follow right now, potentially, but it's not the same as saying you've got to go through the process of overturning the law and not having the president veto it, or overturning the president's veto. Here, another president gets elected, they just get to change it. They don't get to do that with laws. They don't get to do that with legislation. They can fight it. They can fight for a change, but it's very different. So I think even going there, and in this situation, if that's the debate that needs to be had or should have been had, then again, I think it's a different situation. We're trying to challenge something that was part of the law that was passed by Congress. Again, religious exemptions were made. If they weren't made, different case too. Does it mean there couldn't be a case? No. I wouldn't say that you couldn't make the case. And certainly I think the Little Sisters kind, the religious groups, they could make the case. But it would be different I think tougher for maybe a Hobby Lobby type company, even a closely held, though they could still make a case. It's just the government here, I think, made it that much harder to defend. It's why they've had a terrible record in court. Out of the cases, there's only one that hasn't been granted an injunction, all the way through. So it's a tough time arguing for this, and maybe now they're looking back saying this was not the right way of getting at this.
I have a question. Why is the line seem to be drawn between for-profit organizations and non-for-profit organizations? I understand that for-profit corporations benefit from limited liability, but they also have tax penalties. Why can't all of a sudden, a corporation who decides to be a for-profit corporation all of a sudden just lose the ability to say, I'm also a religious corporation. For example, a Bible-selling company that caters only mainly to a certain part of the community, more like Christians who buy from them, can't say, I cannot support this based on my own religious objections.
Well, is that because it's the line. It's a very important line between saying for-profit corporations get huge benefits from the law. I mean, you treat them as though they're being burdened. They're not being burdened. A for-profit corporation, the for-profit corporation was invented essentially just after the Revolution and became significantly used starting in about the 1830s, and then swept the country. And why did it sweep the country? Because it was a terrific way to organize capital. It gave you wonderful legal benefits. Those wonderful legal benefits depend upon there being an iron ring around you, around the corporation and the shareholders. Once you pierce that ring, you no longer have what we think of as a corporation. You've got something else. And that's the nonprofit corporation. Historically, the nonprofit corporation has always been porous. It's always been recognized as just a collection of people who've organized in a corporate form to advance a common end. But they don't get any economic benefits from it. It's just more efficient. But when you organize as a corporation, you get huge economic benefits. If the religious Bible seller wants to get his religious exemptions, then don't demand at the same time the benefits of the corporate form. Nobody forces you to become a corporation. You can act as a partnership, you can act as a sole proprietorship. There are lots of ways you can make money without insisting upon getting the benefit of the corporate form. But once you want the benefit of the corporate form, you know what? The burdens come with it. And you just can't have a one-way street where you get all the benefits, but whenever you don't like the benefits, you say, well, ignore that thing called the corporation. It's really me.
But of course, nothing would stop the government from doing that. They could say, these closely, they could cover that. I don't think that there would be a question about that. The second, just to answer, I think the court will get to that. We'll get a question about the basics there. And the court, the government's position was, Solicitor General's position was, this has never been recognized by the court. Chief Justice Roberts shot back really quickly, but we've never said, it couldn't be recognized. And
corporations cannot take the Fifth Amendment. Why can't a corporation take the Fifth Amendment? Because it has no soul.
Can it come down to the religious exercise, what they were talking about? Not generally the First Amendment. Obviously, we know in Citizens United they can exercise some when it comes to the speech. Can they exercise when it comes to religion? We'll get an answer. We will get an answer, and I think it's up in the air until that happens.
Isn't there also a popular misconception about this employer mandate in itself? That there's a misnomer in the media that there is an employer mandate on the Hobby Lobby to have insurance, whereas they could just pay the tax of $2,000, which would actually be far less than the $400 million cited by them. It would be something like $23 million going to the federal code. So their argument that it's going to be punitive fines which will absolutely crumble their business is just a complete fallacy.
Well, but you're talking about then dropping insurance coverage. This came up in the court in the oral argument. If you then say, but it's cheaper to drop the coverage, pay the penalty. And Hobby Lobby is very serious. We haven't fully, because it did not come up in court. Interestingly enough, the government did not brief this. So and I think it comes down to when you actually look at the long term here. If you don't provide first of all, there's a religious issue that could then come up. That's the first thing. Because now you're saying, okay, if you don't want to violate your conscience, don't pay for insurance for people that work for you. Well, what if you feel like you have a duty to do that? So they said, well, why don't you just raise the salaries? If you raise salaries, you've got to pay tax on that, both ways. The individual doesn't get an exemption like they do for health care. And the company has to pay taxes on that. So you get taxes there. If you've got the situation, and then they've got to go and buy, they have to go buy an insurance plan outside of what they could get as a group plan. So there are more problems than just it's $2,000, so it's less of an economic issue. And I think that there are ways to look at what is accommodating enough.
But I don't know of any religion which requires a corporate obligation to provide health insurance.
to treat your employees well. The court's not going to look past that. I mean, just they're not. They may. It's not really an issue here. But if you say it, if you say part of my religious belief is taking care of my employees and making sure they have
That's not what
insurance.
they're saying.
Yeah, they have said that. Hobby Lobby and Conestoga Woods both. All the cases I've seen, they've said that that's important to them to provide insurance the first or second pay for a brief.
So I think we can take one more question. Somebody who hasn't. Two more you can say? Okay. Go ahead.
So I'm not a lawyer, so I apologize in advance if I don't use the proper legal terms.
So all of a sudden, I like you much more.
Okay. But I was reading a few amicus briefs on behalf of the government, and they talked about like different ways that the contraceptive mandate addressed discrimination, and one was that in a way it sort of addresses gender discrimination that women face since they do have unequal access to health insurance and to health care. And the other is that I think there was an LGBT group that filed a brief on behalf of the government saying that this may also translate into other issues beyond just contraception.
I mean, one thing that we haven't talked about is the slippery slope, right? The so-called slippery slope. If you let this go, if someone doesn't believe in homosexuality or doesn't believe in transgender or providing services for somebody who is transgender, then do you draw the line there? If someone doesn't believe in vaccinating their children, do you not allow vaccinations to occur? I mean, this can go down the slippery slope to every single issue. And so,
actually, immunizations fall under all the same categories because they're all separate. They're in the same.
right, they're also on the same like public health
Preventive
realm.
services.
So there's a very strong, a different compelling interest there because the vaccinations don't work unless there's group.
HPV, it's not a herd immunity.
Right,
Again,
HPV is not herd immunity, but
You also
measles
have
is.
exemptions made. If government starts creating exemptions, it's a different situation than me just saying, my religion, I don't like this, so now I'm challenging the court. That is everybody who's in law school knows that's a much tougher case to bring. Then the government started giving some people exemptions, but not me. So now I'm gonna go for the same one. Very different.
Well, I mean, there's an interesting, I mean, we've mentioned this before, but that's a very interesting argument because that penalizes the government for trying to accommodate. Once they start accommodating, they get on a slippery slope where somebody's going to say, well, you didn't go far enough, so the whole thing gets knocked down. So the answer is they don't accommodate at all. And that can't be good from a free exercise perspective. That's exactly the worst incentive to send to the government. But the point that you made is such an important point, and you were just beginning to make it before you kindly stopped. And that is, this is not about hedonism. This is not about a woman's ability to say, it's my body, I can do whatever I want with it, and I don't care. This is about equality. This is a deep equality issue. No society has ever achieved anything close to gender equity without allowing women to control their reproductive lives. Because if they have to come out of the game, like if you think of the competition of life as a game, they have to come out of the game and sit on the bench while they have their children, while the men are scoring points in the game. They will always be behind when the buzzer rings. The only way that you can give them equality is to give them control over when their reproductive lives will either take them out of the game or not take them out of the game. And that's, in some sense, the deep moral issue. One of the, I think, unfortunate aspects of the abortion debate and the contraception debate is that very early it got centered on the idea of personal autonomy. That somehow this was an autonomy issue where selfish women wanted to do selfish things for themselves in a hedonistic way. And that's not the strongest debating position you can have. But what it's really about is whether women will be equal in this culture. And they will never be equal in this culture unless we give them complete and strong protection of their reproductive lives.
So Mr. Sekulow, I know we promised you that you could get to your next
Oh, no,
appointment,
it's
but if you wanted to have one last word.
You know, I would just, I mean, it's thanks for having me. I know the view is probably not shared by many, but I think it's important to discuss the angles and the truth, because it's tough to get that in the news. It's tough to discuss what we got into and the different ways of looking at it. It's important, I think, from those who could be making public policy one day, who are not necessarily lawyers, because you're going to have to deal with us. And you can see that how these things can result from good intentions seem pretty basic to massive outcry protesters outside the court on issues that you didn't think were going to be as controversial. And then secondly, just to, again, I think it's going to be a very interesting case. It will define, for some part, where these corporations can go. I think only at the closely held level. It's not going to reach shareholders, and I think only when there's situations where these kind of exemptions are set up. And it could be that the court even says, you got it, but there's a compelling interest. This just wasn't the right way of doing it. We didn't spend as much time on that. But the least restrictive means test, I would close with that, is that the court could say that we do think this is right, even if you do have a religious claim. They don't even have to say there is one. They say even if there is one, this is so compelling that you've got to give that this is okay, but this was not the way to do it. So come up with a better way to do it. Here's some examples. And that could be another way that the court handles this that may be less controversial.
So we have a lot to think about as we're waiting for the opinion. If you guys could all join me in thanking our speakers.